Article 14 of the Constitution talks about equality before law, equal protection of the law. And what are the exceptions to the Article 14? President, governor, foreign emissaries, all these are the exceptions to the Article 14 of the Constitution. And then Article, and also MLAs. Also have MLAs and MPs also have certain exceptions with regard to Article 14. Also they have freedom of speech. MLAs and MPs have unrestricted freedom of speech, and their actions within the legislature cannot be questioned by the judiciary. So with regard to this, there are exceptions or exemptions to the Article 14. Equality before law is based on rule of law. It says that no person shall be discriminated. All are equal before law, and all shall be punished equal for equal violation of the law. And this equal violation of the law has to be established by ordinary courts. And there is equal protection of the law. It is about positive discrimination or affirmative action towards the unequals. So treating the unequals as equals is inequality. It is based on the Aristotelian concept. Article 15 prohibits the discrimination of citizens on the grounds of sex, race, religion, caste or place of birth. However, there can be positive discrimination towards women and children, and also socially and educationally backward classes. The 93rd Amendment Act has come into existence, which has provided for the educational reservations for the OBCs in private and public educational institutions other than the minority educational institutions. And after that we have the 16. It provides for the discrimination in public employment on the basis of sex, race, religion, caste or place of birth. In this case, there is certain factors that can be discriminatory, that is place of birth, but Parliament has to make a law with regard to this. And the other thing, religion can be a discrimination for religious institutions employment, but Parliament has to have a law. On the other hand, there can be reservations. Socially and educationally backwardness can be a criteria for reservations, and it is not the economically backward classes which has been spoken about over there. In this context, the Indira Sahani judgment is important, which has stated that if they are not adequately represented, and if there is the 50% is the upper limit of the reservations, merit shall not be compromised, and also this exists only at the entry level. But 77th Amendment Act have extended it to the promotions. 81st Amendment Act has given for the backlog positions to be taken forward, and 85th Amendment Act has provided for consequential seniority. And then 17th article, it prohibits the discrimination, untouchability on the basis of caste, that is untouchability. Untouchability is not defined. Untouchability has been later, Offences Act is later changed to the Civil Rights Protection Act. Article 18 abolishes the titles. Here we need to differentiate between a title and an award. Award is for some academic achievement, and title is based on hereditary. Titles are abolished but not awards. This is Article 14 to 18. 19 Article 19(1)(a), freedom of speech and expression. And whatever the medium you can choose, you can express your views and opinions without any fear or favor. There are certain reasonable restrictions, that is 19(1)(a), 1(b), 1(c). They have security, sovereignty and integrity of India, public order as the discriminatory these things. 19(1)(a), it has defamation, contempt of the court, protection of foreign, that is with regard to relations with the foreign countries. All these can be the factors for reasonable restrictions. 19(1)(b), it takes right to form and assemble, take possession, etc. It do not provide for right to take a strike or a bandh, etc. 1(b), reasonable restrictions can exist with regard to sovereignty, security, integrity and public order. 19(1)(c), it is to right to form an association. The right to strike for the associations is absent, and in this context, the right to strike authority of the unions is being handled with the Industrial Acts, Industrial Disputes Act, not under the right to form the associations. And here there is another thing called as right to form associations. Public morality is also a reasonable restriction. And then 19(1)(d), freedom of movement, general public interest and the protection of the tribal interest. These are the restrictions. 19(1)(e), freedom to settle. There are two things, to domicile and also to reside. And here also there are two restrictions, the public general public interest and also in the tribal interest. 19(1)(f) is removed. 19(1)(g), right to freedom of vocation. In this, qualifications, licenses, monopoly. These are the 3 points. Article 28, there are 3 points under this. Ex post facto legislation, no double jeopardy, and then no self-incriminating evidence. No ex post facto legislation applies only to the criminal things. Double jeopardy, it will not take into consideration the administrative acts. And the third thing is, we have this self-incriminating evidence. Taking the blood samples, etc., they do not come under the self-incriminating evidence. Article 21, right to life and liberty. Procedure established by law, due process of law. Procedure established by law looks only at means. Due process of law looks at ends. And in this case, justness and fairness of law is varied. The substance of law, the parliamentary law can also be varied. The judicial review power is extended under due process of law. Because of this, natural justice also has come into existence. And the third thing is, the concept of positive liberty has entered into India. And most of the rights today are being expanded by the Supreme Court judgments because of the liberal interpretation of Article 21 of the Constitution. Article 22 of the Constitution, it talks about, gives protection against arbitrary arrest. One shall be informed about the grounds of arrest. He has to be produced before magistrate 24 hours, excluding the time of travel and holidays, and he shall not be detained for more period than authorized by the judicial magistrate. And then we need to, that is Article 23-24, right against exploitation. 23 prohibits the human exploitation and human trafficking. 24 prohibits the employment of the children less than 14 years in hazardous industries. And then 25, freedom of conscience, freedom to profess, practice, propagate a religion. Here, with regard to the practice, the essential religious practices is the doctrine brought in by the Supreme Court. Propagation has to be read along with the religious freedom of conscience under Article 25. Article 26 determines the rights of religious denominations. 27 prohibits the taxes on the religious institutions. 28, religious instructions in the educational institutions has been mentioned. Article 29, any individual who has this language, script and culture has the right to protect the same. Article 30, any individual who has a separate language, any citizen who has a separate language, script and culture, he can establish the educational institution of its own and it enjoys the right to property. And Article 31, it is removed. But Article 31A, 31B, 31C exists. Article 31A with regard to the acquirement of various estates, companies and right over the minerals by the state. 31B talks about the schedule 9 of the Constitution. 31C talks about balance between the fundamental rights and DPSP. When 39B, 39C comes in conflict with 14 and 19, 39B, 39C overrides the 14 and 19, that is part of the 31C. 32, it talks about the writs. Habeas corpus, mandamus, certiorari, prohibition and quo warranto. Then is habeas corpus, it talks about show me the body and there is no locus standi onto this. It can be issued against the private individual to mandamus, do the work. It can be only issued against the public authority. Certiorari, prohibition only on judicial and quasi-judicial bodies. Quo warranto, what is the authority you have? Certiorari, quash. Prohibition, stop the proceedings further. So these are about the writ petitions. 32 to 226. Under 32 Supreme Court. Under 226 High Courts. In any extension of the writ jurisdiction of the High Courts can be done by the Parliament by law. And it is stated under Article 35. And then what is Article 33, 34, 35? 33 talks about restriction of the fundamental rights of the military and paramilitary forces. Article 34 talks about imposition of martial law. Martial law only affects the fundamental rights. National emergency affects the fundamental rights and also the interstate, center-state relations. Martial law, that now normal courts do not function. In the case of the national emergency, normal courts will function. And 35, 8, Parliament the power to make the laws with regard to certain Article 16, and then with regard to Article 32 and also with regard to 34, 33 and 34, indemnity, etc. These can be made by the Parliament. That is what is stated under Article 35. With regard to the characteristics of the fundamental rights, they are justiciable, they are political in character, they are negative in nature, and these can be amended. These are not absolute. Done.